alimony. There were a couple of questions asked by my colleagues and the witnesses. What is your understanding of the current state of the alimony law is with respect to somebody turns retirement age, they've been paying alimony, have an agreement, and counsel do bills hypothetically at 3 dates. Can you just give us some insight into what your understanding is with respect to the law, the burdens, when the burden shifts? And what happened?
I think that it's clear under the statute that obviously if you have a pre-Alimony Reform Act agreement that survived and that it doesn't have the abilities therefore to be changed. If you have a merged agreement that you also you have to have a showing of a material change in circumstance, we're going to get beyond the age of 67. I think we're going to continue to see a lot of cases come down that are going to interpret what is happening. When you turn under the statute now, when you turn 67 and you reach the retirement age, the burden shifts at that point for clear convincing evidence to make sure that that's what the judge has to look at to see that type of evidence to see if there's going to be any termination or a change in the alimony.
Now, when you talk about that last part of it, the last part of your answer, what type of countervailing equities, circumstances, if you will, would you consider as a judge where you have two folks who are 67, let's just say, let's say that one is getting, and I might have mentioned this hypothetical to you, one's getting $300 a week to pay me in Social Security, the other one recently retired, getting about $600 a week in Social Security. You've got retirement assets on the payor side of about $500,000, all post-divorce retirement rule. What do you do with that?
I think that right in the statute that there's some direction there that you have to look at whether or not their medical insurance is being paid, whether or not what the health of the parties are, what the income is. You have to look at all the different factors under the statute. I think that as far as in your example, I think that perhaps the best that you're going to get in that situation may be like some half of, to equalize some sort of the Social Security obligations. You're going to have to look at where those parties are a lot of it goes to the health of where those people are, if they're continuing to work, what other assets they have.
Yeah, and I always say that, we hear a lot of answers from nominees. We had a district court nominee this morning from my district. District court, superior court, whether it's a bail issue, it's a custody issue, it's an alimony issue. A lot of this stuff is so fact specific that we ask you hypotheticals, but there's no way that a hypothetical can capture every potential fact that you're going to hear about. So, I certainly get that. I think my colleagues get that, with the exception of maybe Council Kennedy. But
so you need intelligent judges. That's why I'm on the bench.
Okay, thank you for the alimony answer. Now, child support. Let's just. What is your understanding of the deviation, and can you give us some examples of when you might deviate from the guidelines, either up or down?
So, child support under the guidelines of the Morales. So there's an obligation on the court to follow the child support guidelines unless they make specific findings based again on the facts, fact-driven analysis. So unless there are specific findings, there can be a deviation either up or down from the payor to be paying to the recipient spouse. Some of the things that are often looked to are whether or not there are medical costs or extracurricular expenses for the children, a lot of expenses relative to their parenting time, whether or not there are travel expenses perhaps, whether somebody is living below the poverty level. There's a catch-all for to make sure that the child is receiving proper and sufficient support from both households. If there is one of the parties incarcerated, I believe is one of them. So again, it's fact-driven. I think that in practicality, I'm not just talking about the checklist, but in practicality, if the parties come before the court, and they have an agreement for support to be not a child support guidelines amount, sure that there is no duress in that situation. And they have two lawyers, or if they don't have lawyers, that make sure that there isn't something going on behind sort of the scenes there, that where there isn't duress or somebody's not quite understanding what's going on.
And the other area I wanted to touch on briefly was restraining orders. I know that in speaking to you, you've represented both, men and women, been on both sides of the beam, defending, requesting. What's going to be your approach to restraining order hearings? And I think that folks in the probate and family court really get the impact of restraining orders in a way that maybe, just strictly district court practitioners don't, because they don't see the nexus between what a district court judge might do and then carry over to the probate and family court, and how sometimes there's so much prejudice created you can never recover your client from the issuance.
So I have done on both sides of restraining orders. I've done many restraining orders, both in the district court and in the probate and family court. And while there is a need for protection of victims from domestic violence, there certainly has been an uptick in restraining orders that have been sought, really a weaponizing of the marital home, and being able to stay in the marital home, or weaponizing of children and custody. And I think that it is imperative that those cases that come before have hearings that elicit testimony, direct testimony from both sides, because I don't think there's any other way to have a keen ear to the facts, again, to be fact specific of the case. I think we have to have very specific findings that goes to whether, if there was abuse, or whether or not there is a reasonable fear of imminent physical harm. That's the caption that those restraining orders are issued under. And again, I think that it's important for the judge to hear from both sides at a two-party hearing.
Yeah, there's another word there I didn't know existed in the probate and family court. That's evidence. You say that.
I just want to clarify there. So I said that it's important before they're issued for there to be two-party. Obviously, emergency restraining orders are completely appropriate and should be issued. Okay, I want to make it sound like there have to be two parties there for an emergency order, but that once you get to the 10-day time, that rather than it be through through counsel, who are very seasoned and can leave facts out, or have things portrayed a certain way and be very good advocates, you start hearing from parties is the best way to ensure that you have facts.
I completely agree with you. That's probably one of the most comprehensive answers that I've gotten to that question in a lot of judicial confirmation hearings, and I like the fact that you said that there should be very specific findings, and that's, I think, some frustration for parties when, at least in the district court, they check boxes. There are no specific findings, and I think that it's important that judges do make findings in those instances, rather than just say, in fear of serious imminent, what are the specific findings? What did the other party allegedly do? And we said that would make you easier to take up on an appeal too. So I think that's important, for people's rights, judges. I think a lot of those are tough cases to have flipped. I don't know if you've had the experience to take them up, and the restraining orders, it's really hard to get those overturned, even when you think that they're absolutely egregious. And I've seen a 258 order. Woman went in for a 258 harassment order, and the court on its own, sua sponte, the district court basically converted it into a 209A. And they're totally different legal standards, right? It was like, what happened to me a month ago? So the imminency element, which I don't think is given enough weight in these hearings, imminency. What is the imminency? What happened? Not what happened to me 2 months ago, but so even a case like that was taken up, the case wouldn't flip it because of so much discretion. But I appreciate your answer. I think that always an evidentiary hearing, cross-examination, so the judge can assess the credibility of witnesses is very important. Let me ask you this, it's a question that comes up sometimes in the chamber. In in probate and family court, let's say you have a multi-day trial. Let's say it's gonna be a 4-day trial, that's really gonna be a 4-day trial, even if you start at 9:30, 10 o'clock. So let's say it's scheduled for a 4-day trial, but you don't finish. And then the judge looks at his or her calendar and they say, I can't get you back in here for 6 months. It's like, they would never do that in the district court, I mean, they would finish it one way or another, they would finish it. And, I just think that it's such an expense to clients, and to have, you're basically retrying the case in 6 months, you're gonna go back over everything, and I mean, I'm sure the judge took notes, they can listen to the recording, but I mean, what would you do? What would Judge Allen do to try and, help the parties and the attorneys finish that case without saying, I'll see you guys in 3 months, 4 months. I won't remember a thing about the case, and you'll have to reread everything. But I mean, what can you do? What would you do to try to get that trial done?
So I think that the resolution of that is gonna take cooperation between counsel and the judge. I mean, it's not purely on the courts, just because they have, they put it out, because inevitably this happens, is that we take out our calendars, and the judge says, okay, I can see you in 10 days, and, Attorney Brick says, oh no, I can't, I'm going to Bermuda, and he says, okay, well, maybe how about 7 days after that, and, Attorney Canzaro then says, no, I can't, I'm skiing, so it's, and then all of a sudden, so it's gonna take a real collaboration between counsel to, to be willing, also to be flexible. There's one judge in Middlesex who she often says, okay, I'm bringing you back tomorrow afternoon. But the mornings are difficult because of motion sessions, contempt sessions. But a lot of times the afternoons are quieter, and we're going to do it. We're going to do it next week on Thursday and Friday at 2:30, and you're going to get 2 hours in. And I had to do that, and my calendar is free. I don't love doing it on Friday afternoons, but I think that's what it's going to take is a commitment from counsel also.
Yeah, I just think it's important for people, I know what happens, and sometimes it's not within people's control, but, obviously, if you're cognizant of it, try to accommodate. I don't have any other questions. You've got great background, professional and personal. You deserve to be here. You've earned it. I will be very proud to vote for you next Wednesday when your name is put before this council. Congratulations to you and to your family.
Good afternoon. We spoke on the phone something, and what I like to do, especially with probate court judges, is to check on what I think are the important things for a probate court judge, because of the emotional aspects, because of the fact we deal with more pro-se litigants than any other court, and quite frankly, before I became a judge in private practice, I did a lot of divorce work, and there was one judge in particular who treated attorneys like they were in kindergarten, in terms of, don't you talk to my court, all this kind of stuff, just absurd, ridiculous stuff. So the most important thing is your demeanor and your ability to deal with every kind of case, and just to be a real human being when it comes to treating other people respectfully, with dignity, and so that you don't feel like you're in a kindergarten class. So my practice is to call other judges in addition to talking to the nominee themselves, because I want to know what other people have observed about it. And, there are some people who are very polite to judges and rude, outright rude, to the clerks or the assistant registers or the court officers or the people that, move the cases along in terms of the registry of probate. So I'm very happy to say that I actually had one judge before I started making calls who called me as she was about to get on a boat with the grandchildren to go on vacation. Who basically said, you're they're the best thing since butter toast and bread. Think about it, in terms of your demeanor, your ability to try a case, your knowledge of the law, but the fact that you have a great ability to settle cases, which is really what it's all about. My father was a lawyer for over 50 years, and he said, nobody wins when you have to go to trial. It's when you can resolve a case that is satisfactory to everybody, that everybody wins. And I kind of have that philosophy as I practice law. So you know the law, you are great people, you are great people, you've got a great demeanor, and you know, the questions, or the things that we talked about, answers to your questions here today, all have really convinced me that you are the kind of person that we need on the probate board. And I hope that you can still be that way 20 years from now. Because I had friends who went on the probate court bench and it just wears on you something. I guess the only thing that I would suggest to you is, if you really have something that's under your skin, take a recess, blow your cork in your chamber. Because I had 298 cases that I absolutely almost lost it. So, you're going to do a great job. I don't have any other questions, and I wish you the best of luck, and I'll be hoping for you next week.
Thank you, Council Rhino.
Thank you. We had a lengthy conversation. You were very helpful. You did a great job over the phone. Unfortunately, I didn't think I was going to have questions, but of all these questions, I took a lot of notes, so I have some more. We won't get into the removal statute. We talked about that. We won't talk about visitation over the Skype, the computer. We discussed that. Judge Donnelly, he explained, the alimony, and then he said, we'd look at 2018, tax, we'll use it with and without the deduction. When you determine alimony, you look at the last 3 years or the last year? How do you do that?
When you look in
To
determining
determine-
what income to
Yes,
use,
yes.
I think it depends on the nature of the income. So if you have a W-2 employee, you have a W-2 employee, and I'm not looking at the last year, I'm looking at the last pay stub. Like, you're looking through the lens of where we sit right then. I think that if you have a self-employed individual that has seasonal business, that's landscaper, for example, I'd probably look at several years, 3-4 years, because if you have many landscapers plow in this winter, and so if you had a snowy, it goes up and down, so you want to.
Make it easy, someone like you, a lawyer.
I'd probably be looking at 3 years, and not necessarily averaging. Maybe I would take 4 years and drop the high and low, and then average. There, you can do all sorts of different things.
Okay. But you're looking at multiple years with someone.
Yes. Unless I get some evidence that there is, if it's somebody who's relatively new attorney, and the income is going steadily like this.
I understand. On the retirement, you talked about under the new statute. If someone is at retirement age, 66, 67, is it your understanding, let's assume there's no medical issues, there's no, just a normal, whatever the normal situation might be, that alimony shall, I think that's the word, shall terminate at retirement?
Yes.
Other than some type of medical situation, is there any other reasons why alimony would not terminate?
So alimony shall terminate at retirement age. The statute said if it's a 20+ year marriage, and there's a potential for more than the statutory configurations, then that's when it turns, and the burden is on the recipient spouse with clear and convincing evidence. The medical issue is one. There are very few facts and circumstances, I think, that would be.
I was going to say,
that,
other than
right,
medical, what
I
could
don't-
be
there
that
really,
I can think of? I can't.
under the statute, there is an inability of a spouse to work because they are victims of domestic violence at the hands of that really, really small issue, or small fact patterns, but really the health and the ability to get into the workforce. And I will say, I've actually seen in cases, judges now put into judgments sort of warnings to recipient spouses that they are, that at some point this is going to time out, and that they are on notice that they need to get back into the workforce and get themselves educated and be able to earn, because this is coming to a close.
Well, let's assume one of the spouses does not work, and for that matter, has never worked. But there are no physical limitations. Let's even make it easier that there's no minor children. All children are out of the household. Again, I've never done a divorce case in my life, so I used the wrong terminology. Bear with me. Do you give an earning capacity to the non-working spouse?
You can,
Again, with no health issues.
you can't, with testimony, you can attribute income. And that's called for in the statute, that if somebody is not working and they reasonably could be, then there is an attribution of income.
So if you were to assign, I'll use the word earning capacity, that this person, even though this person doesn't work, the non-working spouse could make $20,000, $50,000. Do you take into consideration, I know the economy is great now, but do you take into consideration, yeah, this non-working spouse could work, but there's just no jobs around. Do you take that into consideration, or do you look at the fact, I do workers' comp, so I'm thinking workers' comp, they don't look into that. Hey, if you can do something, hey, we're going to give you an earning capacity. Hey, there may not be any of those types of jobs, but you could do that type of job. What do you do in that situation?
I think that you do take into consideration the market and the marketability of that person. I have seen many judges, or most judges, actually will attribute at least minimum wage at a full-time basis. So so that will put you up to, say, $440 a week times 52, so somewhere in the 23,000 range. So quick math, but
even for a college-educated person, you'd only give.
No.
I mean, I didn't ask that. I know I didn't ask that. I got the greatest wife in town. I am the most fortunate guy in the world. Okay, my wife, she's like the household manager. Okay, she doesn't have an official job. The kids is an official job. I get it. But let's assume my kids are in college. But we're like that. So, but she's college educated. She does not have what we consider she's not going to an assigned job somewhere. She's our household manager. Title she likes. Would you assign someone like that
so
more than minimum wage? And like, I have no idea. Give me like.
So assuming that you're getting divorced, her very good attorney is going to bring in an expert and is going to give me expert testimony on what her abilities are in this, with her skills at her age and in this job market.
So it could
and
be
I
a lot.
Make those findings.
It could be a lot more than minimum wage.
Absolutely.
Okay. Child custody. Do you attribute, I know there's the formula, whatever the formula is, but now the kids are in college. Does the child custody change do you lessen the child custody? Because you obviously have you could deviate. Child support, I'm sorry. I told you I didn't know the terminology. Child support. Can you deviate from the statute if the kids are in college? And I'm not saying they're not commuting, wherever they are.
So absolutely. So that's one of the major areas of discretion for the court is when a child has graduated from high school and they're now away at college. They are not depending on the parent or the recipient parent for support day in, day out. And you can certainly hear testimony, find facts as to what that parent is still providing for the child, how often they come home, how often they don't, are they at USC in California, or are they at Birmingham State, what what are they being provided, and also what has been the contribution of both spouses, including payor, into the college bill. So, you can't be, of course, are mindful and should be mindful of how much they're paying towards college, and therefore what should their child support obligation be for any remaining children in the household.
Thank you. Now, my next question, we talked about this. Your law firm, we're talking about marital assets, okay? Everything, as you said, is the marital asset. The books, the car, the bicycle, I get it. But now we have someone who's a solo practitioner, a lawyer, and we also have, I'm gonna give two other examples. Think of my neighborhood. We got the funeral home, okay? These people are all close friends of mine. The funeral home, they go to all events, they go Sunday, they go to church, they do the collections, they go to everything in the community. And why do they go there? The funeral home. So it's a one-man shop because he wants people to come to him, okay? And that's different. And same thing with the local dentist. Okay, I'm not talking like 20 dentists in the office. I'm just talking about Dr. Joe, okay? He's the dentist, and I go to Dr. Joe because I like him. He's in my neighborhood. Lawler Funeral Home, okay? Bobby Lawler, I've known him my whole life. If something happened to me, go to Lawler. But if he sold it, I'm going somewhere else. So, and again, if I'm using the wrong words, but those people have your practice, the funeral home, the dentist have goodwill. People are going to those folks because there's goodwill, as opposed to Home Depot. We all go to Home Depot, but I have no clue who the owner is. No matter who it is, I'm gonna go to Home Depot. Capitol Grill restaurant, I'm going to Capitol Grill, no clue. Am I saying that right? When we get to marital assets, obviously the Home Depot, Capitol Grill, that's definitely maybe a 50-50, but those other three situations could be totally different. In dividing the marital assets, it's not like you have 50,000 in the bank. That's easy. 50, whatever.
So I think that in valuing those businesses, so again, like your friend, Mr. Lawler, the funeral home, if he gets divorced, like his wife's very good attorney is going to hire an expert or hire somebody to value that and appraise that business. And they are going to try and value that business with very little personal goodwill. They're going to say, it doesn't matter that if Mr. Lawler is there or not, people are going to go and have their services at Lawler Funeral Home. And therefore, because it's enterprise goodwill rather than personal goodwill, that is going to be something that's going to have a lot more value. But if it was, but Mr. Lawler's very good attorney is going to have somebody appraise the business and say there's a great amount of personal goodwill there. And with that key man in there, and that key man person, that's going to reduce the value of that business. And in single operation law firms, so like solo practitioners, reduces it down practically to zero most times, because you take that person out of the law firm, then there's going to be little other than hard assets there.
Okay, so now you have two experts. You got Lawler's, the spouse one and the spouse two. Well, let me just, let's do the law firm. It's a little easier, okay? Now you have the law, the law firm, okay? The experts, they're crazy, so far apart. Would it be okay for the spouse who owns the law firm to bring in, like, attorney so-and-so as a witness, attorney Kennedy, and say, yeah, I refer this guy 100 cases a year, and I do it just because he's my friend. And if he weren't my friend, I wouldn't refer him any. In other words, to show that we're having, that the same your situation, that a 30-year business is because of Attorney Kennedy referring you business. But then he could come in and testify and say, well, he would be showing that it could, because the other expert is saying something differently. He wouldn't be able to testify to say, yeah, I've been given, Attorney Allen cases for the last 5 years, that's a 30-year business, assume we could prove that. Would that be a factor to show that it's all your personal, your goodwill, that's the only reason he's going to you, and if it weren't for you, he's not going there?
I think that I would have Mr. Kennedy talking with my expert, and the expert, so I would call it with the expert who's gonna come and testify at the trial,
Okay.
rather than having all of sort
I
of
understand,
these
so
bits
that's
and
a good
pieces.
point.
Yeah.
So the expert could put in his report.
Right.
I talked to Kennedy, this one, that one, to see how he came up with the, okay. That's good. What does this mean? Maybe what I'm talking about. The terminology, double dipping. What does that mean to you?
It means when somebody wants not only a part of an asset, but the income that's also derived from the asset.
So almost the same thing we're talking about. In other words,
It's a close call.
Lawless, they want half of the value of the funeral home business. It made $1 million a year. I want 500,000, and I also want to base my alimony on that $1 million.
Correct. So
That's
they
what-
want to value the business and receive a buyout of the asset, but they also want to receive alimony from the income derived.
What do judges do? I didn't ask you. on double dipping.
Can I ask him to answer?
So double dipping, I get it.
Right, I think it's fact driven, it's fact specific, on the kind of business. I think it depends on whether or not that's really on how big the asset is and whether or not he's gonna stay there, is he gonna go somewhere else. There's so many different.
No, but
factors.
basically on the 3 hypos that we talked about, the law firm, the dentist and the funeral home, assume there's no building or anything like this. This is just the law firm, just the dentist, just the funeral home. If a judge determined that the funeral home, were marital assets and, we're gonna divide it in half, and then the judge also ordered alimony to be based on the income, that's something you may consider as double dipping.
Yes.
Okay. Good news. I think he answered all my questions. No, but I gotta tell you, honestly, you are really, I've been here a long time. I don't mean today, but I've been really fortunate. I've been really fortunate on the council for a number of years. I liked your emotion today. No, I'm totally serious. That's you. I know I don't know you, but that's a good thing. That's a good thing. I can only imagine how proud your family was. I'll never forget, my parents are dead. I'll never forget that first day I got sworn in. And my father, who was a former state rep and whatever, he was in the back of that chamber, the House of Reps. It's something you just don't forget. And they're looking down, I'm really happy. I thought you answered all my questions yesterday. It's always with the probate nominees that I do ask a lot of questions, historically. It's not like something new. I think you're great. I thought your witnesses were excellent, and it's a big day for you, but it's going to be a better day next Wednesday when the council approves you. It was great to talk to you, and you did a great job.
Thank you.
Thank you. What was your mother's maiden name?
Her maiden name was Bullerwell.
How do you spell it?
Bullerwell. The farm was Nunez.
Any questions?
No. She's real close and she's completed. Yeah, I actually don't have a lot of questions. We spoke for a really long time on the phone and I really enjoyed the conversation with you. The only question I have is, do you have any experience dealing with same-sex couples in divorces or child custody cases or anything like that?
I've done same-sex divorces. Handled one case, which I think was possibly one of the first divorces, but I ended up doing the modification sometime later.
Yeah, I I mean, it's just another divorce, but as our civil rights are under attack in the country, I feel very blessed that we live in Massachusetts, because I don't think we'd be as attacked and rights stripped the way that they're being stripped across the country right now. It's a very scary time, for many minority communities, but the LGBTQ community in particular, it is very, very important. I really don't have any other questions for you, honestly. You're eminently qualified. You have a very nice, not just demeanor, but way of explaining these things, particularly with my colleague. No, I'm teasing. I'm teasing. No, you really do. And you've, even when the train goes off the tracks a little bit, you were able to follow it, which takes a lot of skill sitting in this chamber I've watched. So, best of luck to you. I hope that we do see you on the bench. I think you will serve us well. And wait, I do have one question. And we may have spoken about this a little bit on the phone. This court, I think, is as all courts are, this is a very challenging court. I think mentally and spiritually. And when I mean that, I don't mean spiritually, really religiously. I just mean to your spirit. Do you have a strong support system to help you get through some of these times? Right here, you all pledge to
Just
hold
around a small piece of it.
because it's very important, and especially today, where judges are under attack in the Commonwealth for a multitude of things. And I think this is a court where people, their emotions run high, people run hot. You don't know what somebody's going to do. And not when you're just sitting on the bench, when you're at home. And we can encourage people to be civil and to conduct themselves with decorum. But as I saw in my district, with Judge Feely, a very, very conservative judge, when he made a ruling that people just literally did not understand, they were protesting. They were harassing the court employees. I spent an entire day at that court, meeting with every single individual person because they were so shaken up by the absolute uncivility of people, not just the letters, but the protesters outside, in their inability to understand the law, or the law as that judge read the law. And that's the judge's prerogative when they sit in that chair. I may not concur, I may not understand. It doesn't matter. It's your courtroom. So I do ask everyone going to all the courts now, be prepared for that. Be prepared for the press being on your front steps. Your children and your husband, you have to be prepared for just the incivility, I can't think of another word for it, of people not understanding and disagreeing in a very disagreeable way. It is never okay. You can always disagree with people, but you can't threaten their lives, and you can't say they should be fired. I mean, that's not how we work. Up until a few hours ago, we were still a country of laws. You all know what I'm referring to. But we're on a very, very slippery slope when we allow these things to happen. So, and I would say the same thing as I almost call him Judge Judenville, as Counsel Judenville said this morning, with judges are being put in a predicament with ICE agents coming into their courtrooms wanting to take people into custody. I have no business doing that in our state courts. They want to do it outside. That's their business. We've got some real serious public safety issues with folks who are immigrants or non-immigrants or legal or not legal here. Whatever you want to know, no one's illegal. You may be undocumented, but you're not illegal. But if a judge is put in that situation, it's really unfair, and I think it's a real again, a slippery slope of the federal government coming into our jurisdiction. It seems they love the separation of the two when it suits them, but when it doesn't suit them, there seems to be, no matter what administration it is, when it doesn't suit them, they want it. But just please, I know you think of these things, but unfortunately, I feel we really need to have these conversations because I think it's part of the new reality. My only other thing is that I hope that at some point you will go into schools or to groups with young people, about being a judge and how you got there, because I think it's a wonderful story. And I think it's really important for our young people, in particular girls, to feel empowered that they can actually do this. You know, you thought you were going to be a teacher, you ended up being a lawyer, very well may end up being a judge. This could be the very first step of many steps, who knows? So, best of luck.
Thank you.
Mr. Chair.
I don't have a lot of questions. We spoke quite a while on the phone, and I appreciate your time. And, I know you told me about the parents, we spoke on the phone, and your mother passed away in work. You said, I can tell you right now, they're in the room. They're very, very proud of you. I'm not just so sure that they're going to get math. I want you to look at page 9 of the Governor's Council questioning. You have that?
Oh, boy.
So I think it's the 9th page, you're not done yet, so. The question where the C number 3, approximately what percentage of your practice is litigation? And you say A, 1% civil, B, 1% criminal,
Because I give everything 200%.
D, huh?
That's because I give everything 200%.
Yeah, that's right. Now, I'm not that smart, as I indicated earlier. That doesn't add up to me. Are you working like
No, it's.
double days or something?
The other was supposed to be 0, but I
No, mom and dad wouldn't be proud of that. Huh?
No.
No, I think you're fantastic. We had a long talk on the phone, and any questions. I got a number of telephone calls. I told you some of the people that called, about how great you are as an attorney and as a person. I don't do any probate work. And, I did ask you one question. I want to see if you change your answer. Okay? Because my vote might depend on it. If my wife puts me in, you can be fair and impartial. Because the last time you said yes, I said I couldn't vote for you.
No.
I'm going to be voting for you next week. Thanks.
Councilor Devaney, do you have any questions?
I'm last. Thank you for all the time. We actually were 10 minutes there after they closed. But it's a question. First of all, I asked her anyway, I asked every process. So, when did you find your application? March 6th. And when did the JAC? May 15th. So, 2 months. Then after you reviewed everything and see what happened, did you do a JAC?
Yeah, so I was notified that I had been voted to the diligence phase, and then after that, I was,
So this is 2018, it's May 15th, or?
so throughout the summer last year, I just was notified that, I was going to diligence, and then that I was being recommended up to, some weeks, in the executive office, and then I met with, Attorney Casey and Attorney
Sharon Casey.
August 9th.
During your JAC interview, was the government
She was there for a portion of it.
so you came to the interview? So now that's August 9th. Yeah, okay. And so then we have.
I was notified in March of 19 to meet
What was that date?
March 20th, approximately.
2019. So, going on at the and we have days later, Executive Secretary of JNC, we should do for their application in for the Nantucket. Interesting. So, that process took about 90 days from beginning to end. And we've been here for 2 years and that's usually the process. So that's usually the process. So it, now, I was gonna ask you, something that's timely. Would there be any reason for you to transfer?
In the tape session in the court. I think that generally no.
You know, it's a different probate court, but if there was a non-citizen, a father, who was in case, you know, right, was getting divorced, and, he'd been alleged criminal, and had been deported twice, would you allow ICE to come in and have him?
Obviously, this is a timely subject matter, and but it's certainly something that if I'm supposed to be confirmed, that I assume have some counseling on from the chief and have some conversations about.
I mean, this person comes in